Good evening, Sri Lanka. Welcome to yet another episode of Law and Order, and to discuss about a topic that we spoke last week as well, intellectual property. We do have with us Dr. Nishantha Sampath Puncheva, a senior lecturer at Colombo University, part of Faculty of Law, Department of Commercial Law. Good evening to you, Doctor.
Good evening.
We spoke about copyrights at length last week. I'd like to move on to patenting. We did touch upon the whole topic as well. But how do someone who's probably coming out with a novel idea, who probably believes that no one would do that in the next 3 to 5 years or so, would get his product or his idea patented? What do they need to do first?
Further to our discussion at the last session, I would like to emphasize that if an inventor, so this new idea should have should have originated from an inventor who found a new solution. So if an inventor finds a new solution, that person by following the intellectual property law, by virtue of intellectual property law, should be able to obtain intellectual property protection. We call patent protection for that invention. Otherwise, the invention can be copied by somebody else, can be stolen by somebody else. So the sooner you have the invention, it is very necessary, I would say imperative, it's a must have requirement that you file the patent application at the National Intellectual Property Office of Sri Lanka. We call NIPO or NIPO. So you need to file the patent application with regard to the invention that you have invented, you have found. So it is the first thing that you need to see whether I have invented something. Simple test. You can find yourself that whether there was a long felt need in the technology. Was there a problem in the technology? Did I find a new solution? So you can just look at that invention and decide whether this is a new solution to a specific problem in the field of technology. Problem, solution, test. So if you have a solution, if you have found a solution, then you need to see whether you can obtain a patent from the National Intellectual Property Office. In that, you need to be aware of very specifically what can be patented in Sri Lanka. By reading through the provisions of the Act, one can easily understand certain subjects, certain subject matters are not patent eligible. For example, plant, animal, microorganism, method of doing business, and nuclear material related inventions, inventions that are harmful to the social order, morality, will not be patented in Sri Lanka. Those are generally known as non-protected subject matter, ineligible subject matter. When you have these inventions, when you have an invention, and if it is a product or a process, and this invention is not falling under excluded subject matter, what cannot be patented. Excluded subject matter means what cannot be patented. For example, animal, plants, naturally occurring plants cannot be patented. So if you are within the patent eligible subject matter, then you need to also think about whether this particular invention can be patented by applying conditions of patentability. In order to obtain a patent in Sri Lanka, the inventor has to satisfy 3 requirements. First one, the invention must be new. Second, invention must have an inventive step. Third one, invention should be industrially applicable. If I just go into bit of details, then novelty means invention must be new. Invention must not be disclosed anywhere in the world. It means we call prior art, the status of knowledge at the time of my invention. So, if you look at the prior art, if you search prior art, if something was disclosed anywhere in the world, then I would not be able to obtain patent. For example, now a Sri Lankan inventor invents something, a new face mask. You got to find out whether there is any invention relating to new face mask that I have done. So, that is the first thing that you have to see. If your invention is seen in the prior art, that is the knowledge that existed up until my invention came in. So, if my invention was disclosed anywhere in the world by written publication, oral disclosure, or by use, then your invention is lacking the requirement, the standard of novelty. Are you clear?
True.
And then if you satisfy novelty, then you need to see whether this invention is adequately non-obvious. That is called invention involves an inventive step. Inventive step in the simple language can be explained that the inventor has significant contribution is significant in view of the previous knowledge, right? We call posita, person having ordinary skills in the art, should be able to see that this is not obvious finding. If it is obvious, then you would not satisfy inventive step requirement. Are you clear? I think this should be clear. This should be made clear to the to everybody, because inventors quite often think that I can just satisfy novelty. Novelty means it is new anywhere in the world. It is not enough. It does not suffice, because you have more advanced requirement. That is, my invention should be new, not only be new, but it also represent a significant contribution beyond the existing knowledge. That is called non-obviousness in the US and other countries. In Europe and in Sri Lanka, we follow the British style, British common law tradition, and we call it inventive step. The step novelty, and then you have to go beyond novelty, and there should be a significant contribution over prior art. Third requirement is that the invention must be able to be used in any kind of industry. If you found a new solution to COVID-19, then you should be able to use that as a medicine, or as an injection, and as a vaccine, or whatever it may be. So, it should be used in any kind of industry. So, these are the three requirements that any inventor in this country should be mindful of when you apply for a patent, when you make an application for a grant of a patent in the Sri Lankan Intellectual Property Office. So, three requirements. These requirements are called conditions of patentability. Patentability, right? Novelty, inventive step, and industrial applicability.
And Doctor, if I may go a step further from there, if we want to patent our product globally or in another country, what do we do?
Very important, because I think this is where Sri Lankan inventors have not or have explored very little. Why? We do not have much known international patents in this country, very little. Even if there are, it is very handful of inventions, patents being obtained in other countries as well. I would say this because I have not I have also seen the statistics. Our inventors are looking at only Sri Lanka, the local market, but you have horizons of opportunities around the world. So you need to obtain patent protection in other countries for the simple reason that Eshan, that now you obtain a patent in Sri Lanka, it is a territorial right. This right can only be enforced in Sri Lanka. Suppose you invented a new device to deliver goods to COVID affected areas, and if you have not obtained a patent in India, Indian producer may not be able to obtain a patent on this invention because you have already obtained, it is prior art, it is the existing knowledge now, but he will produce in that country because you do not have exclusive rights in that country. You can only stop importation of that particular device to Sri Lanka. So this is something our inventors, our business leaders should think about, because I think as a nation we need to be very conscious, we need to be focused on this. We need to obtain patent rights abroad. For that, very short, in brief, we can follow Paris route or PCT route. Paris route, you can Sri Lanka is a state party to the Paris Convention for the protection of industrial property. So patent is an industrial property, and if you want to file individual patent application in the countries, selected countries, you better file international patent application in other countries, other jurisdictions. In law we call jurisdictions, by using Paris rule. But if you want to follow the WIPO, World Intellectual Property Organization route, that is there is a route called PCT, Patent Cooperation Treaty. So Patent Cooperation Treaty route is administered by the World Intellectual Property Organization, we call WIPO. So you can file single application and you can designate many countries as much as you need, and by single application you can secure patent rights in many jurisdictions. I think if you are eyeing, if you are exploring opportunities in significant sophisticated markets, European markets, US markets, maybe East Asia, you need to follow this PCT route.
And that's very important. Doctor, you mentioned about territories and how to go about it and all of that. My next question would be that with regards to geographical indications, because in the previous session also we spoke about Ceylon tea and Ceylon cinnamon in particular, two brands that Sri Lanka owns so dearly. How important is GI?
As we had also a little discourse on this, so Sri Lanka is a GI rich country. I would say that because of the natural factors, environmental factors, we have a unique heritage of geographical indications. If you just see mango, the Karta Colomba mango, if you see rambutan, if you see the Ruhuna curd, gems, blue sapphire from Ratnapura, city of gems. Sri Lanka has many geographical indications all over the places, and only thing that we have not utilized these geographical indications for the development of for the economic development, rural empowerment. For example, take Ceylon tea. Ceylon tea is the best tea in the world, undoubtedly. Ceylon cinnamon is the best cinnamon by far that you can available anywhere in the world, right? It is a remarkable selling proposition for Sri Lanka. Just simply take Ceylon tea, Ceylon cinnamon. We have black pepper, and then we have other GIs also. But we have this potential remains untapped. That is, we have a geographical indication in the IP Act, but unfortunately we don't have any mechanism to register Sri Lankan geographical indications as geographical indications. If you go to European markets, Ceylon tea is not being able to extract the real value that Ceylon tea has in its unique offering.
And that's very important, Doc, because I think people need to understand the importance of securing our rights, because I think Sri Lanka Tea Board over the last decade or so has done so much with regards to GIs, and Sri Lanka, as you mentioned, clearly has a huge advantage of dynamic differences when it comes to certain regions, and we ended up registering 7 regions as well in the last 3 to 4 years, thanks to 150 years of celebrations that we had in 2017 and so on and so forth. Even with regards to cinnamon, it's the same, because we talk about it being the most popular around the world, but you see Indonesia and Vietnam now leapfrogging our production capacities. We had 17,000, whereas they've gone up to 60, 70, 80, 90,000 per year, and things have changed quite a bit. But still, for all, people still look for Ceylon cinnamon because of the quality that we have produced. What do we do to protect ourselves from being exploited elsewhere?
Eshan, I think the policymakers, I would say the policymakers of this country should be able to understand the real problem that we have to face. Now, I know that Sri Lanka attempted to register Ceylon tea in the European Union a couple of times, ended without success. Why? For the simple reason that we don't have the registration of Ceylon tea as a GI in this country. Same applies to Ceylon cinnamon. In the absence of registration in the country of origin, then what happens? There is no obligation on the part of the foreign country to protect our GI as a GI. Now, this is, now you can find, I have been to Europe, and I know it's an everyday item, no, Ceylon tea, but you will see Ceylon Assam, and then you will see Ceylon Lloyd. Teas originating from other countries are branded as best-selling Ceylon tea. So that is where incidents of misappropriation would occur.
And what could, for instance, let's say Sri Lanka Tea Board for that matter. Now, we've seen this many a time where name Ceylon tea is used by pirates for products that are not produced in Sri Lanka. If we do come across a situation of that sort, what do we do? How can we rectify the situation? What is the methodology that we need to follow?
Rectifying is good, because we need to fix the problem. We need to at least address the issue, going to the root of the problem. The root lies. The root is there in the Act. We have merely mentioned by section 161 that Sri Lanka protects geographical indication. Nevertheless, there is no registration system for geographical indications in this country. In the absence of a registration system, we may not be able to insist another country to protect Sri Lankan GI in that particular country. There is no reciprocal obligation on the part of that country. That is the issue, very issue that we have. I think we policymakers, lawmakers should think twice. Have we been proper, have we taken proper remedial action to fix this problem?
Absolutely, and I think that's up to the policymakers, as Dr. mentioned, hopefully going forward to rectify the situation and protect our rights, because Ceylon tea and Ceylon cinnamon are world famous for being the #1 product when it comes to tea and cinnamon. And going beyond from GIs, Doctor, looking at trademarks, trade secrets, we touched upon that topic before as well, which has a huge commercial aspect to it, because it's economically beneficial to the person who has it, especially when it comes to trade secrets, even more than trademarks. Trademarks also do play its part. How do we take control of a situation of this sort?
These two aspects we should take on one by one. I would first offer my explanation to as regard to trademarks. Trademark is another IP tool. IP tool is most used in this country. Business leaders at least forget about the other IP rights. Concentrate on trademark, because that is your brand. Branding, however, branding is not in our DNAs yet, because we need to go beyond the present level, because we need to think about branding beyond simple trademark. We need to think about futuristic trends. In other countries, you have many non-traditional trademark. For example, smell mark, motion mark, and also touch mark, taste mark, and many things. But we in Sri Lanka, we only protect visible marks. So I think we have to think. Think beyond the perceived boundaries that we have in our act. So trademark is a valuable asset. Trademark differentiates your goods from my goods. So if you want to identify the origin of the product, you need to see the trademark. So you are better known by your trademark. And so trademark also should not forget about service marks, certification marks, and collective marks. The collective marks and certification marks are very effective instruments in other countries. For example, if you have a region of producing apple, and all the farmers into a cooperative society will get together and market your products together by using a common brand. That is called collective mark. And if there is an institution to certify, our Ayurveda can do this. No? Now, there are many mushrooming Ayurvedic institutions. So if the Department of Ayurveda can think of common logo, authentic Sri Lankan Ayurveda, then you can also promote Sri Lankan tourism. And people will be able to go to that place with confidence. Then you can simply eradicate fake places. No?
Absolutely, Doctor. We have come to an end of the show. Unfortunately, time has caught up with us, and there's lots more to discuss with Doctor. On behalf of the show, I'd like to thank Dr. Nishantha Sampath Punche for being with us and sharing his expertise on a very timely topic, and something I think a lot of Sri Lankans and policymakers, businessmen and individuals could take something out of and hopefully protect yourselves going forward, and especially whatever ideas, that novel ideas that you might have going forward. And it's time for me to say goodbyes on today's edition of Law and Order. See you same time, same place tomorrow as well, rather next week as well. It's bye-bye from us.